Good afternoon for our listeners on the East Coast, and for everyone else, good morning. We're going to be starting the webinar in just a moment. This is a webinar presented by Cohen Seglias on asset protection planning. It's part of a series that our transactional wealth preservation practice group provides as a resource to our clients and business associates. Good afternoon. My name is Brian Lawton. I am a partner in the wealth preservation group here at Cohen Seglias. I also work in the business transactions. Speaking to you from our offices in Pittsburgh, I'm joined today by my colleague, Whitney O'Reilly. Whitney is an attorney in our wealth preservation group, and Whitney is located in our Philadelphia office. I'd remind our listeners that on the dashboard for the webinar app, there's the ability to pose questions. If time permits, at the end of our webinar, Whitney and I will try to answer any questions. If we're unable to do so, either because of time constraints or because of the detailed nature of your question, be assured that Whitney and I will respond offline after the conclusion of the webinar. So our goal today is to provide a high-level overview of asset protection planning, what it is, why it's important, and how and when to start. Whitney and I will speak about some of the common strategies that we utilize for clients when developing an asset protection plan. The purpose of this presentation is just to introduce you to the issue, hopefully to spark some thoughts and assist you in understanding the importance of the issue. Because we will discuss in greater depth in this presentation, something you should understand that this planning ahead is key to implementing a successful asset protection strategy. And I think probably the first step is to just give you a solid working definition on what asset protection is. And for those of our listeners who don't have access to the slides because they're just participating by telephone, simply stated, I would describe asset protection planning as the strategies and techniques for protecting your assets from potential creditors. There's a lot of misconceptions about this topic. First is the notion that wealth protection is for the very wealthy. In addition, there's a sense of maybe a cloak and dagger aspect to wealth protection. Asset protection. People hear about offshore companies located in some Caribbean island, secret Swiss bank accounts. There certainly are strategies that involve using offshore structures, but what we're going to talk about today are topics that anyone can employ, whether it's a small business owner, a professional such as a medical provider, an accountant or an attorney, and really anyone who wants to protect their hard-earned wealth. So everything we're going to be speaking about today are strategies that can be implemented in the United States, where you live. And a final introductory point, because we have an audience that's spread all across the country, is that laws on creditor-debtor relationships vary very widely from state to state. While the strategies we are discussing have a broad reach, the circumstances are going to depend upon your individual situation, depending on where you live. What we're not going to be speaking about today is anything that's unlawful, whether it's to defraud creditors, avoiding responsibility for your past actions, or engaging in criminal conduct. You're entitled to protect your own wealth. And the strategies that we're going to be covering today are perfectly legitimate. These are going to be laws that have been implemented in the various states and the federal government that exist for your protection as a debtor. We as attorneys are here to give you solid advice and help you solve your problems. The working assumption should be that your asset protection plan is going to be tested. And so from that standpoint, anything that's going to be unlawful is just opening yourself up for probably more problems rather than less. I start about the most fundamental aspect of asset protection is having insurance. So the best asset is liability insurance for purposes of protecting yourself. Asset protection planning is a supplement. It's not a substitute for insurance. No matter your circumstances, it's a safe assumption that there's a liability policy that the insurance industry has developed for your protection, whether it's the humble automobile policy or a homeowner's policy, commercial general liability for business and property owners, employment practices, policies, professional liability for attorneys, doctors, architects, engineers. There's a policy out there for you. And so we're not going to be speaking today about the different types of insurance coverages or the appropriate amount. That's the role of the insurance professional. I am touching on the topic because the importance of asset protection planning is to supplement your insurance coverage. There's a lot of risks out there that your assets can be exposed to that may not be the subject of insurance protection. Or there's very often the circumstances where claimants who are trying to reach your assets are going to attempt to do an end run around the insurance coverage. These strategies that we're going to talk about today for asset protection planning purposes are ones that are designed to add an additional level of protection behind insurance. Before we move on from this topic, there is one last issue I'd like to note, and that's umbrella insurance. And for those of you that aren't familiar with umbrella insurance policy, it's a type of policy, extra liability insurance. It goes beyond the coverage limits for whatever your primary insurance policy would be, whether it's a homeowner's policy for individuals or a commercial general liability policy for a business property owner. And while we're not here to talk about the types of coverages, a rule of thumb that is used is very often is to have an umbrella insurance at least equal to your net worth. For businesses, especially ones that are in a high-risk industry, very common to have a policy with umbrella insurance limits that might be a multiple of what your net worth is based upon the type of liabilities that you will be facing in your business. So why engage in asset protection planning? First and foremost is wealth preservation. What we're trying to accomplish here is we're trying to reduce or eliminate the threat of claims against you and your assets. Developing a plan allows you to recognize the potential of threats and a response before a problem arises. The key with asset protection planning is to be proactive. There's also an additional consideration, which is that this isn't a one-size-fits-all situation. The types of threats that the persons are going to be facing are as various as the persons that are engaging in the planning. A small business owner can be involved in a high-risk industry, but she operates through a business entity that gives her liability protection from the company's operations. By contrast, a medical professional has personal liability for her professional actions, even if she's in a practice that's structured as a limited liability business. The approach that these persons will take to the issue will differ because the risk profiles are different. There's an inherent trade-off as well in asset protection planning that is very much based upon the client's individual situation. It may be difficult or impossible to develop a strategy that's going to protect all of your assets, protecting you from any and all claims. In addition, asset protection planning and tax and estate planning often do not mix very well. And you as the client, with the guidance of your professionals, have to make a decision where you're going to put an emphasis, recognizing that you may not get everything that you want in order to accomplish a particular goal. A very simple example is that gifts to family members are often a very good estate planning technique, but they can be bad for asset protection planning, as we'll discuss shortly. When to start planning to protect your assets? You can't start soon enough, but you certainly want to start planning before a claim arises. This is because late planning usually backfires. Events are the master of all of us. On this slide, I've identified a number of instances where asset protection planning may be useful. If you have been subjected to a lawsuit, verdict is entered against you, and there's creditors who are attempting to force a claim against you or your business in order to recover on that verdict. If you are subjected to a bankruptcy proceeding, whether it's voluntary or involuntary, divorce or separation, and claims happening in estate proceedings. Events become the master of all of us, and from that standpoint, if you think about some of these events, consider whether they can come upon you unawares. Often, we put issues to the side because we're dealing with the press of our everyday lives, business, and we don't think about how to deal with a situation until it becomes too late. Reactive asset protection planning can often be ineffective, and in many instances is actually counterproductive, increasing your problems rather than decreasing them. Why late planning usually backfires is that there are a series of laws that have been enacted in states and federal laws that are designed to protect creditors. We've talked a little bit about there exist laws out there to protect debtors that we use for purposes of asset protection planning. States which are looking at the interests of their public recognize that there's a necessity to balance both creditor and debtor protections. And so states have enacted some form of what's referred to as a fraudulent transfer law. The purpose of such laws are to reach an asset a debtor's transfer to a third party in order to take the asset of the creditor's reach. It's a way to kind of go back and undo what someone's done for illegitimate purposes. In addition, under the federal United States Bankruptcy Code, there's Section 548, which is a fraudulent transfer statute that gives the trustee the same power in a bankruptcy case the creditors would have under a state fraudulent transfer law. Fraudulent transfers is a topic that we could probably spend an hour discussing on its own, but just to talk to you a little bit about what's involved with this area, because it is so important, because this is really the topic that when you're planning, you're thinking about how do I protect myself from a fraudulent transfer claim. And so the first step is there's different types of fraudulent transfers. The courts characterize as actual fraud. This is what you and I would think of as a fraudulent transfer, a specific intent to avoid satisfying the liability. I'm going to put the asset out of reach because I don't want to pay you. There's a second category, which is referred to as constructive fraud, and that's a little bit more nuanced. The definition that's given to this is by courts is to transfer property without receiving reasonably equivalent value. And the effect of the transfer is that the person who is transferring the property is either insolvent or as a result of the transfer is left incapable of dealing with their own financial affairs. So what does that mean in practical sense? The legal definition for it is very convoluted and difficult to understand. So think about a real practical example, that I transfer my house to my children in order to move that asset out of my estate. That might be good estate planning purposes, but it could be bad from asset protection planning. Think about, again, that circumstance. What is it that I have received in exchange for making that gift to my children? If it's nothing, then my creditors could very well say that that transfer was entered into for the purpose of defrauding them. Rarely is there solid evidence of what constitutes actual fraud. No one's going to admit that they were trying to avoid paying their creditors. And so what the courts have done is they've developed a series of what they refer to as badges of fraud. This is an evocative name that comes out of this law, which is very old in its origin, but it's the types of circumstances courts look at in the context of the transaction, and they say, you know what, that's a good indication that there was a fraudulent intent behind this, even though the parties who are involved in the transaction weren't going to make it. There's about 11 factors that the courts have developed. We're not going to cover all of these, but some of the examples that are associated with this are transfers to a family member or someone that you're very closely related to, what's referred to as an insider, where I transfer the legal ownership of the property, but I retain the effective control and use of it. If I engage in some efforts to conceal the transfer, if there are claims that are outstanding against me at the time that I make the transaction. This again goes to the whole issue about planning in advance. If the problem's here and I start dealing with it on a reactive basis, I'm often making the situation worse rather than better. And as I mentioned, often late planning backfires. And this is because the fraudulent transfer laws are very sweeping, whether it's the federal bankruptcy provisions or state laws. Courts have the power to unwind the transaction, to undo what it was that I did. They can enter a court order against me, prohibiting me from engaging any further transfers of my property. In addition, probably the most effective remedy is that the third party, the person that I transferred my property to, can be swept into my dispute with creditors. Again, turning back to my example of mom gifting a house to the kids. So what's the effect that there's insufficient resources to pay mom's creditors? Then her problems can become our children's problems. With that, we're going to turn over to focus on strategies for protection of personal assets and about how careful planning in advance can be helpful to avoid or eliminate some of the risks that I've talked about earlier. And so with that, I'm going to turn over the presentation to Whitney, and she's going to be speaking about some of these common strategies for personal assets. So go ahead, Whitney.
Awesome. Thank you, Brian. That was great. Now we understand a little bit about asset protection and what it's not. And now we need to talk about what we can do to protect your assets during your lifetime and after you've passed away. So here we're going to talk about the strategies. And remember, each person's situation is different. And something that might be good for one person might be not good for some other person. So make sure that you follow up with your wealth or your estate attorney. Take all of this information back to them and say, what are the things that I should be doing? So first we're going to talk about strategies for personal assets, and then we'll talk about strategies for your business assets. So what I'm going to talk to you about today, we're going to talk about how we hold title to our assets, how we can incorporate trust in planning for creditors, what the homestead exemption is, how we can use life insurance in our plan and understand whether or not a creditor can get to these sorts of things, funding our retirement accounts, and maybe even having things like pre- and post-nuptial agreements as part of our plan, our asset protection plan that starts right now. Remember, like Brian just spent a bunch of time talking about the Fraudulent Transfers Act. I can't tell you how many times I have a client reach out to me and say, you know, I'm a doctor and something happened a couple of years ago. Anyway, I just got some information that I'm going to be involved in some lawsuit. My firm has malpractice insurance, but I want to make sure that my individually held assets are protected. Can I give them to my wife? Can I put them in a trust? Can I do something with these assets so that this person in this lawsuit can't get to them? Well, that's too late. We've done planning now too late. My answer normally is, now you can't do that because the Fraudulent Transfers Act comes into play. So what can we do before that to safeguard our assets? So hopefully nothing like that happens, but if it does, your assets are better protected for you or your family members. So the first one we're going to talk about is holding title to assets. So this is one of the first things that I get from my clients when I see them. So when we get together, I talk about all their assets. And we own assets in lots of different ways. Most people have real property, real estate. People have assets in stocks or investment accounts or bank accounts. People have life insurance, retirement accounts. So we want to go through each of those individual assets and say, what is it about this asset that we can either do something about to protect it for ourselves right now, or maybe even in an estate plan or through our will, we can give some of the protections that we can't get right now to our children or our loved ones. So this first one is how we hold title to ownership of property. Normally right now, if I was in a room talking to you guys, I'd say raise your hand if you have a home, right? But most of you, I know, I could see the question answers, but I'm going to guess that all of you would say yes, of course we have a home. Well, do you know how your home is titled? So on the deed to your property, does it say your name, which is sole ownership? Does it say something called tenants by the entirety, which means you and your spouse own it together? Are you in a state, Brian and I both practice, I'm here in Philadelphia, he's in Pittsburgh. I practice in Pennsylvania and New Jersey, but we have attorneys and we have a presence in an awful lot of states here in the United States, and not all states work the same way. We do have community property states. Pennsylvania is a non-community property state, so we'll talk more about it that way. But it's really important to know, because if you come to me or you have assets, let's say held in California or held in Texas, we might want to understand it a little bit more, because divorce protection may be different if you hold an asset in California versus if you hold an asset here in Pennsylvania. Then we have something called tenancy in common. Maybe you own a piece of property with your brother and sister, or maybe you own real estate that you're renting out with a bunch of other guys. Brian will talk more about how maybe that's not the best idea, but that would be tenancy in common. What happens to that is, if you pass away, the rest of the members, it will actually, that tenancy in common, it passes directly through your estate, and either through the intestate code, or if you have a will, the will says what happens. And a lot of times I get that question from people who think that just that property would pass to the other members. Then of course we have joint tenancy, which just means you each own property equally. And when one of you passes away, the other owns all of it. And then of course we can hold real estate in trust. Now you might say, well, how does a creditor access these things? Which way should I hold my home? And my first answer is, if you're married, your home should be held by tenants by the entirety, which means you and your spouse own it together. The federal government gives us some super uber creditor protection if we own things as tenants by the entirety. It is very, very hard to get access to that tenants by the entirety property. And I can't tell you how many times I have clients come in and see me, and they hold their house as joint tenants with their spouse. Maybe they either bought the house before they were married, but the people who were selling them the house or whoever drafted the deed didn't realize it, or for whatever reason, it's just held in a different manner. It's really hard for creditors and even the federal government to get to property that you own by tenants by the entirety. But the only people that can have that designation are spouses. So if you're not married, you don't get to have that protection right there. What I can say about community property states, even if you hold things, now we're talking about lots of different creditors here. We're talking about, let's say, credit card debt, but we're also talking about a creditor, which would be a divorcing spouse, right? Or a creditor who could be the federal government in taxes. And all of those are slightly different. So if we think about community property, if you own something individually, it's still subject to be divided into in divorce in, let's say, California. But if you're here in Pennsylvania or anywhere really on this northeast, we're a non-community property state, the distribution is going to be an equitable distribution, which means, one, it may or may not be included, but normally individually held assets are not considered marital assets. We'll talk about this a little bit further when we get to pre- and post-nuptial agreements, but for divorce protection, it is really important to have that prenuptial agreement in place, and if you're already married, to have that post-nuptial agreement, so that depending on where you're located and how you hold title to your assets, you know what happens if you were to get divorced. So those are the different kinds of ways we can hold title to assets. And we're going to move forward. I think I've got the next slide. So the takeaway we can get from holding title to assets is, if you're married and you own a home, owning it by tenants by the entirety will give it super uber creditor protection. So that's the first takeaway piece from this, which is really, we're giving you sort of a basic layout of asset protection. We're not going to get really too into detail in any specific way, but this is one takeaway that you can take. You don't have to pay an attorney to do this. So you won't hear that very often, because attorneys normally want you to pay them something. But go back, look at the deed to your house, and if it doesn't say tenants by the entirety, reach out to your attorney and ask them why it doesn't, and if it offers that creditor protection, which we know that it does. So the next thing that we're going to talk about is holding assets in trust. You may own some property in your own name. You may own it with your wife. You may own it with other people, but you might also own it in a trust. And a lot of people, when they think of asset protection, they think about trust. So the first thing that we want to talk about is, what is a trust? Right? I have on the slide here, it's a legal relationship when a person, so we call that person the settlor, grants an interest in property to be held by a trustee for the beneficial use of another beneficiary. What in the world does that mean? Sometimes I liken a trust to, we stick money in a bank account. So there's $5 in a bank account, and the name of that bank account is the trust. So now you can't get access to it. The only person who can access those assets in that bank account, that $5, is the trustee. But it's not the trustee's money. The trustee just has permission to take the money out and give it to the beneficiary depending on what the trust says they're allowed to do. And for me, I'm an estate planning attorney, so we create all this asset protection underneath people's wills and trusts so that we can give the next generation uber creditor protection without themselves having to do anything in the first place. But all trusts are not created equal. First, we've got inter vivos trust, and we've got testamentary trust. And testamentary trust just means that it's created under your will, as in it doesn't come into play after you pass away. And an inter vivos trust means you create it during your lifetime. Another distinction is a trust can be revocable, which means you can change it anytime you want to change it, or it can be irrevocable, which means it's very hard to change. And all of these things matter quite a bit. If you have a trust, it's really important to understand which kind of a trust you have so that you understand what kind of creditor protection you have. A lot of people come to see me and they've got a revocable trust in place. And they say, all my assets held in this revocable trust are protected from creditors, so we're in great shape. We don't even need to talk about asset protection planning. And my answer normally is, if it's revocable and you have control over it, your creditors have access to it too. It's the wrong kind of trust. If that's what you're trying to accomplish is asset protection, it will probably not be through a revocable trust. And then you could have the person who is the settlor, the person who creates this trust, could also be the trustee. That can, of course, cause some problems. If you're the trustee of your own trust, it's a little easier for a creditor to go to court and say, this really looks like their asset. I want some of it for my whatever it is I'm owed. What we want to make sure happens is if we do have a trust in place and we are doing it for asset protection planning, we want to have the things in place that tell the creditor you have absolutely no ability to access that trust. So we talked about the testamentary trust versus the living trust. Of course, you can create a trust right now that becomes in existence now. You can create a trust that comes into play after you pass away. And we always want to make sure that we've got this spendthrift provision in our trust. This spendthrift provision is really the heart of the creditor protection in the trust that says creditors, marital claims, even your spendthrift beneficiaries can't have access to these assets in the trust. So let's talk a little bit about the kinds of trusts that we can use in order to keep creditors at bay. So one kind of trust I'm going to talk to you about is called a self-settled asset protection trust. It's also known as a domestic asset protection trust. Right now, we don't have this kind of trust in Pennsylvania. We do have laws that allow this kind of trust in Delaware, Alaska, Nevada. It's still pretty recent in the estate planning world, so there's not a lot of court cases, but this is the kind of protection that you could take an asset now, put it into this trust for you to be the beneficiary of, and have it not be accessed by creditors. Now, of course, there's always limits. The federal government regarding taxes can almost always access just about anything. It's also hard to avoid child support, and it can be up to a court's discretion whether or not they can enter into a trust. So if you do have a trust, if you do want a self-settled trust, you have to make sure that you do it in one of those states, and you're going to want to make sure that the trustee resides in that state. You might even need to make sure that the assets are in that particular state. So this can often not be an option for people in Pennsylvania, but it is certainly an option for people in other states or people that hold assets in lots of different states. And so the way that this self-settled asset protection trust works is you put money into the trust, you have an independent trustee, someone else like a Delaware trust company or a Delaware attorney. They're the trustee and they have sole distribution on making distributions back to you out of the trust. This can be a little bit hard for people to swallow as well. In order to get the creditor protection that you want, you've got to give up some ownership and control over that asset. So there's always two sides to the coins, and we're always trying to balance our interests to make sure that we're getting as much creditor protection as we need while also having the ability to utilize those assets at the same time. Some limitations on these self-settled trusts. Remember, just like that story I told you when I started talking, that I had a doctor come to me say that there was a medical malpractice lawsuit about to happen, and could he put money into this self-settled trust? That answer is no. It's subject to the Fraudulent Transfer Act, right? So if he had come to me 5 years before and transferred lots of assets into this trust, had an independent trustee, had the right kind of property into that trust, and the trust was being administered correctly, yes, it could have very well avoided any credibility liability. Now, besides that self-settled trust, before we get to the homestead exemption, there's also trust that you can create for your spouses and your children under a well-crafted estate plan. So you can give a self-settled trust that we can't actually create here in Pennsylvania. We can give that to our spouse and our children underneath our will, so that when we pass away, we are giving even better protection of the assets that we have to our spouse and to our children through trusts that look similar to a self-settled trust. Now, these trusts are always trying to be accessed by creditors. So every once in a while, it's important to look, even if you have an estate plan, even if you have trusts under your will that protect assets that pass down to your spouse or to your children or to whatever loved ones are receiving your property, creditors are always trying to access that. So we need to look at it, and we need to look at the rules of what keeps creditors at bay and make sure that our trust is always complying with that. One of the things that we're always having to look at is what distribution standard is in the trust. Right now, most of my clients have a HEMS standard, which means anything that comes out of the trust to or for the beneficiary for their health, education, maintenance, or support can't be accessed by a creditor. That gives us that creditor protection, but it's a pretty broad standard. So your spouse, your children could still get money for what they want. Because remember, we're balancing multiple interests here. We want to have that creditor protection for our spouse and our children so that they can have these assets protected and used for their lifetime. But at the same time, we want to make sure that they actually have access to these assets. So the best creditor protection trust has a wholly discretionary trust where the trustee never has to give money out of that trust to the beneficiaries for any reason. And most people don't like that idea. They actually want this money to go to their family members. They just want to make sure that it has additional creditor protections. So right now, at least in Pennsylvania, we're still good having that broad discretionary standard, HEMS standard, but it's important. If you have a trust or you're thinking about a trust, it's important to understand the ramifications of how to get money back out of that trust and whether those assets are subject to creditor claims. So one of the takeaways from this is, one, look at the title of your assets, right? If your house doesn't say tenants by the entirety, maybe fix that. That was number one. Number two is get an estate plan in place. And even if you can't do this self-settled trust during your lifetime, make sure you offer those benefits to your spouse and your children so that they get those creditor protections for the rest of their life. So if you pass away and assets transfer to your wife in this trust, and she gets into a car accident and kills someone, well, hopefully she has car insurance. And like Brian said earlier, we should absolutely have umbrella liability insurance. I'm not a life insurance or a liability insurance salesman, but umbrella insurance is fairly inexpensive, a good way to protect over top of our homeowner's insurance or our car insurance. But let's say she killed a brain surgeon and she only has a very limited amount of car insurance and she doesn't have umbrella insurance. Then millions of dollars may be taken away from her in this lawsuit of her accidentally killing someone like a brain surgeon. If we have these assets in the trust and they have the right distribution standard and they meet with all the state's requirements for a spendthrift trust, those creditors aren't going to be able to access those assets. And your wife will be able to continue to live on those assets and pass them down to your children upon passing. So that's important. Number 2, make sure we're utilizing trust. And if you don't have a trust, think about getting one. And if you do have a trust, make sure it's the right kind of trust and actually does what you want it to do. The next asset protection technique we're going to talk about is the homestead exemption. The homestead exemption, it's a law enacted in the state where residence is located, and it protects the value of your home from creditors. So we already talked about how to title your real estate. That tenants by the entirety gives uber creditor protection. Here's another exemption that the feds and the state level offer to people who own homes. Because remember, they want us to have home ownership. It's important for us to have that. So it gives us this immunity from for sale. It is state specific. So here in Pennsylvania, we don't really have that exemption, but in places like Florida, I have a lot of clients who spend part of the year here and part of the year in Florida. In Florida, we've got an unlimited homestead exemption, which means if you own a home, nobody can get to that. No creditor can reach that, which is absolutely wonderful. So it's important to have that home and understand that the homestead exemption is there to protect the value of your home. Or maybe if you're not in places like Florida, maybe at least part of your home from a creditor. So important to own that home and then know the state that you're in, whether or not you've got that homestead exemption and what that means. Maybe, like Brian said earlier when he was talking about gifting your home down to your children, that's a question that I have often come up when people come to see me. They talk about themselves or their parents. Should I gift my house to my child? My answer to that is often no, but this is just one of the considerations that you have to think of. If you give your home to your child, you no longer have that homestead exemption, and now we have to worry about your children's liability now that they won't have this homestead exemption because they don't live and aren't actually in the house. So again, we talked about that it just varies from state to state. And I'm just looking over here for a second. I can't chew gum and walk at the same time. So I'm just looking to see if we have any questions so far about how you should be titling your assets, whether or not you should be utilizing trust in protecting your assets, and how the homestead exemption protects your assets from creditors. And it looks like we've got some questions and we've answered them, but they look very specific. I'll circle back to this at the end as well. So if you think of a question now or sometime in the future, when we get to the end of this presentation, there'll be a minute or so that you can ask questions. And of course, our contact information is on the back of this. Please reach out to us at any time. Email, call us with any questions, and we're happy to answer them for you. Now, the next thing that we're going to talk about is life insurance. So both the federal and the state laws include some exemption for the cash value of proceeds of life insurance. But that's really important for us to understand a little bit about life insurance, because I have a lot of clients that come to see me with life insurance and they don't really understand what cash value is and whether or not they have it. Most term policies do not have a cash or surrender value, so they are already protected from creditors. One way that you can make sure that they're protected for your spouse, your children, or your family or loved ones is make sure that you're checking the beneficiary designation of something like life insurance, and we're going to get to in a few minutes retirement assets, which is just we want to make sure that the estate is not the name of the beneficiary of your life insurance policy. because once it is named to the estate, creditors of your estate can actually access that life insurance. And if it's named to, let's say, your spouse or your children, they have no ability to access that. So I'd say that's the three sort of nugget of gold that so far you've gotten from this webinar, which is, go back and check those beneficiary designations and make sure you don't have the estate listed, because if you do have debt, a creditor could try to access that life insurance policy when you pass away if it is payable to the estate. But now we're talking about another kind of life insurance policy, which is a whole life policy, which often has a cash value. And again, most states have exemptions, and the federal government has an exemption that's not accessible, or a large portion of it is not accessible. So having life insurance can be also helpful in keeping your assets, or that particular asset, protected from creditors. This is really interesting. I've worked on this over the years, but actually just finished up a case regarding foreign debt. And here in the United States, your debt normally, and I'm saying normally because there's always exceptions to everything, is that your debt doesn't travel down to your family members. In other countries, it does. So it's really important to understand, if you hold assets in other countries, or you have family members who live in other countries, it's important for them to understand those distinctions, that debt does transfer down. Now remember, some things do transfer down. If you jointly own property, not by tenants, by the entirety, with your spouse, and you owe federal taxes, that actually might get attached to your jointly held asset. So again, run reason to change it to tenants by the entirety, or maybe put some of your assets into a trust. But life insurance can be great also for tax planning purposes, so that when you pass away, life insurance, at least for Pennsylvania purposes, is not subject to any death tax. Pennsylvania, unfortunately, does have a death tax. It's the inheritance tax, where the beneficiaries are taxed on the assets they received, but no tax is due from your life insurance policy. Now, for federal purposes, if you're listening and you have over, 11 point, and this just changed, so I think it's $11.58 million, then you should be really aware of this, because it's a 40% tax when you die, but life insurance is part of your estate. So there are estate planning techniques to actually move it out of your estate, so there's no tax ramifications as well. So life insurance can be a really key component to that asset protection planning. Now we're going to move to retirement accounts. So retirement accounts are a really great way to keep creditors at bay. As long as you have a qualified retirement plan, so that's like your 401k, your 403b, it does not include things like deferred compensation, executive bonus plans. Basically, it is protection from all creditors. Now, of course, I'm saying all creditors, and you can see on my slide that it's not unlimited. Most of these asset protection techniques are not 100% foolproof, right? It's just like having insurance and then having umbrella insurance. It's just another level of another layer of protection that you can afford to your assets for your benefit for your lifetime, or at death to your beneficiaries. So of course, federal tax claims sometimes get through. Same with domestic relations, things like child support, and there is a bankruptcy limitation. So it's pretty protected. The next thing I want to talk to you about is that protection isn't there. It's there for you, and it's there for your spouse. But when you pass away and that asset is transferred down to your children, they no longer have that creditor protection that retirement accounts have. I won't go into too much detail because I could talk forever and we've got to get back to Brian. But there was a recent Supreme Court case that explained that you didn't have this creditor protection, thus brought in IRA trust. So my wealthy clients who have millions of dollars in retirement assets, we put those assets into IRA trusts. But just a couple of weeks ago, we had recent legislation that changed the rules on retirement accounts. I'll have a follow-up webinar and some information on our website regarding the Secure Act. But if you do have an IRA trust, you should check back in with your estate attorney to make sure that it still does what you want it to do. But part of the reason we use those trusts, like we talked about using trust earlier, it can protect assets during your lifetime or when you pass away for your family members. So again, funding your qualified retirement plan, making sure that, one, you have beneficiary designations is really important, but understanding that you've got this awesome asset protection for this particular asset, but it doesn't travel down to your children unless you implement some estate planning tools like a trust. So then we're going to talk about the last topic of personal asset protection planning, and I'm going to talk to you about today before we dive back into business planning, which is asset protection planning for divorce. This one's a tough one. I don't know how many of you on the call are in a first marriage, a second marriage, not married at all, but prenups and postnups are really hard. A lot of people either don't have them because it was a first marriage or feel uncomfortable with them, but they really are great ways to protect your assets in a divorce. So a lot of wealthy families, they want their children to get this prenup because they own a family-owned business. They own a construction company. They want to pass down that business to their children, but they don't like their children's spouse. Or maybe their children don't have a spouse yet. Through your estate plan, through those trusts, you can sort of bypass the need to have a prenuptial agreement and get that same protection that way. So it's really important to look at sort of all these strategies and how they can work together. But again, having that prenuptial or postnuptial is that additional layer of protection that just says, before we got married, this is what's mine, this is what's yours. If we get divorced, this is what's mine, this is what's yours. And it's also important, I often have in pre- and postnuptial agreements, what happens at death with those assets? Of course, you can always afford your spouse more, but it's important to set the expectations of whose assets are what, because we don't know if we have community property assets, non-community property assets. We don't know if your business that transfers down to your child could be subject to having an ex-spouse have some ownership of it. So that's a really important asset protection planning that can be very simple. Most of the times once I get to people who are in their second marriages, they almost all have a prenuptial. On occasion, we have a postnuptial agreement. I don't think they hold up as well in court. Of course, it must be in writing. We want to have it happen well before you're married. We might even want separate representation for both spouses. Some states require it. Some states allow you to waive it. And again, we talked about, giving that trust protection outside of the prenuptial agreements. So I'm going to sort of turn the floor back over to Brian, who's going to talk to us a little bit about strategies for asset protection for business assets. But I just wanted to recap what we talked about, which is when you leave this call, double check the deed to your house and make sure if you're married it says tenants by the entirety, or you understand how it's titled and what it means. If you have a trust, look at that trust and see what it says and see if it does the things that it's supposed to in order to afford you creditor protection. And if you don't have a trust, reach out to an attorney and figure out if you should have one. Find out if your state has the homestead exemption to know whether or not your house would be protected in a creditor claim. Make sure you've got life insurance and that you've checked the beneficiaries and they're not the estate. And make sure that you've funded your retirement account, because that's a wonderful federally given to us way to protect assets. And if you or a family member are thinking about getting married, that would be a great time to bring up prenuptial and postnuptial agreements. So this is sort of personal strategies for how to protect your assets. And now Brian's going to talk to us about strategies for business assets.
Thank you, Whitney. So I think probably what we'll start with here is structuring businesses. And there's a whole litany of business forms. You hear the names corporation, limited liability company, partnership. And within that listing, there's a subsets. There's a general partnership, limited partnership, series limited liability companies, non-series limited liability companies. Entity selection is probably the most fundamental strategy for asset protection purposes for a business. The issues involved with appropriate entity selection we could spend at least an hour, if not more, just talking on this topic by itself. However, for today's topic, we're going to really make a stark distinction between operating a business in your own capacity, what's referred to as a sole proprietorship, versus operating it through an entity that has some form of limited liability. So what is a sole proprietorship? It's operating a business in your personal capacity, not through an entity. What does it mean legally is that you, whether you transact the business under a name other than your own, are liable for the claims against that business. A very simple example. If I own a piece of rental property as Brian A. Lawton, and if the deed is in my name, then in that circumstance, if there is some casualty associated with that property, a slip and fall, the person who is the owner of that property is me. If there is a lawsuit because someone's injured in that slip and fall, the person who would be sued is me as the property owner. If there would be a verdict that would be rendered against me, it's not limited to that real estate that I own. It's any assets that I would have available to satisfy those creditors' claims. You think about it in the circumstance where Whitney was speaking about how asset protection and titling work in this area. This is a prime example of it. My home, I own it jointly with my spouse, and so from that standpoint, that asset would not be available to satisfy the theoretical creditor who was injured in that slip and fall. So owning assets in an entity is probably the best way to go about conducting your business from asset protection purposes. And that's because of what's referred to as the limited liability, or sometimes it's referred to as the liability shield. And what this is that state laws have established that that when you operate under a business, that business is considered a separate person from its owners. And so the owners are not liable for the debts and the liabilities of that company. If I'm engaged in that business and that business is not successful, the creditors who may have claims against it, they have to look to the owner, not to the shareholders. What I have put at risk in that business is whatever capital I have actually contributed in the form of the stock ownership that I have. Now, it's important to consider that if I operate through an entity, that doesn't mean that I'm completely immune from every conceivable liability that's associated with that business. I'm still liable for my own acts. And what does that mean is I make the distinction. If I'm the president of the business and I make decisions for the business, I have the benefit of limited liability for the consequences of those business operations. So if I'm not successful in that business and creditors have a claim against it, just because I was the executive who was operating it doesn't mean that I'm liable for it. But if I personally guarantee those business debts, the business defaults because I'm not successful, that personal guarantee that I've created is a contract between me and the creditors. And then I don't have the benefit of that limited liability because I've engaged in that contract in my own individual capacity. Some of the limitations that are associated with limited liability. First and foremost is what's referred to as piercing the corporate veil. This is an evocative name that courts have developed for a very simple concept. Under what circumstances, if any, should the limited liability shield of an entity be disregarded? So I lose that benefit of operating through an entity, and I can be held personally liable for that entity's liabilities. This, again, is a topic in its own right that we could have a presentation on, but for purposes of asset protection planning purposes, it's very much a cautionary tale about what to avoid so that I do not lose that liability limitation. It's a very high standard for the corporate veil to be pierced. Courts want to give effect to state laws that create the legal distinction between an entity and its owners, and it's really only in circumstances where I have abused that corporate form, whether it's under a limited liability company, a corporation, partnership, that the distinction between the owner and the entity will be disregarded. And so there's no bright line test that tells you when an entity is veil is going to be pierced. A couple of issues that you can kind of focus on is wrongful action by the corporation, and when there's a disregard of the separateness of the corporation, the shareholder, so that they cease to exist. Wrongful action, it's important to understand what is wrong. So if I do a bad job operating the business, it's not successful, I can't pay the creditors. That's not the type of circumstance that the court's going to pierce the corporate veil. It's where I use and really abuse the corporate form in some fashion to engage in unlawful conduct through an entity and then try to protect myself from that unlawful conduct that I'm really running into this circumstance. Really, for the average person who's out there trying to operate their business in the best way possible, piercing the corporate veil comes in as a result of the second circumstance, the disregard of the separateness of the corporation and the shareholder, so that the two cease to exist. And this is really the recipe for trouble is when you start mixing your business and personal assets and your personal affairs with the business. Very simple examples are buying assets that you're going to use for personal engagement, but you own them through the corporation. Often people are trying to take advantage of tax laws that might give more favorable treatment to an entity owning an asset. When I'm involved in business transactions involving small businesses, and this is an issue you see in small businesses all the time, you often see the circumstance that tractors that's used on the owner's farm when he owns a construction company. It made sense for him for tax purposes to buy that tractor, but it's never going to be used for that business. Bank accounts. Do I have a separate bank account for my business and a separate one for my personal affairs? Am I drawing on the business bank account when I'm a little tight on my personal account? Credit cards, very, very ripe area for blurring the lines. Think about the circumstance in which I'm going to take a family vacation, and I know that the limit on my business credit card is much higher than my personal credit card, so I'm just going to go ahead and use that business card for that personal trip. It's my business. I'm the sole owner. I'm entitled to do with it. I plan on paying the credit card company back. Now, obviously, if I don't, the credit card company can have some issues with how I use that card when I try to assert that that was a business liability. Other creditors, and creditors are ingenious in looking at these issues, trying to find ways that they can break the distinction between the owner and the corporation to pierce that veil. These are all issues that they look at. Probably the rule to guide yourself by is avoid using business accounts for personal expenditures. Next is following the formalities. We talked about some of the benefits of operating a business, but there's responsibilities that are associated with that. Very often, states will impose a tax for operating as a business, referred to as a business tax or franchise tax. This isn't tax for income or taxes I have to withhold for sales, for employee wages. This is a tax that's charged to the corporation for the purposes of operating. In addition, some states have reporting requirements where filings have to periodically be made for the state government. If I don't maintain those formalities, whether by paying those taxes or by filing those forms, the entities, my privilege operating under that entity can be revoked by the state. It's very easy to regain that status, but what happens during that interim period where I have a claim come in? Have I disregarded that entity? Has it been revoked so that it can be argued that I should be personally responsible for the liabilities that happened in that time period? It's really an issue of carelessness, unintended consequences. Prime way in which people structure business affairs is to segregate assets and liabilities into pools. To have separate entities, the goal is to use that limited liability shield to protect assets and operations from claims in the separate entities. Very common example that you see that often in both small and large businesses is that I have my real estate in one entity and then my operating business in a separate entity. And the operating business occupies the space The goal is that the real estate is protected from the liabilities that could come in against that operating business. So is it as simple as I can just set up two entities, two LLCs, one for my operating business, one for my real estate? The operating business occupies the space and just go on about my business. Very often you see clients do that. The thing I would caution is some of the examples that we talked about in terms of the operating the businesses in the right way. Is there a lease between those two entities? Is there a separate bank account for the real estate entity? Is rent actually being paid from the operating entity to the real estate entity? If the answer to all of those questions, or some of those questions, is no, then in that type of circumstance, a creditor who has a claim against the operating entity and there are insufficient assets to satisfy that, very often will be looking at that real estate entity, looking for ways to join the two together, arguing that there was artificial distinction here. The reality of it is, even though those assets were held in two separate entities, they operated as one business. These are examples of very practical ways at low cost that you can engage in asset protection planning. So as we come to the conclusion, and I appreciate we've gone a couple minutes over, so we're just going to finish up right now, is some of the strategies we've talked about. I think that you can appreciate both Whitney's and my presentation today. A lot of these things you can do yourself without even involving an attorney. Obviously, we're here to be of assistance to you, but some of the things to get started with respect to these things is to increase your liability insurance. Review whether you have jointly held accounts, jointly held property. Consider keeping assets separate, both business and personal, and the use of business assets, entities to shield assets, and get that estate plan in place. The thing that we can stress so much with respect to this is plan ahead. We can help you with all of these things, but if we're acting in a reactive fashion, once the claims are in, there's only so much that we can do to assist you. At this point, I'd kind of turn things over to Whitney, whether she has any final words for our audience.
Everyone, thank you so much for taking the time out of your day, and especially out of your lunch hour, to listen to Brian and I talk about asset protection planning. I hope you've got a few nuggets of gold from the things that we talked to you about, and we look forward to helping you get an asset protection plan in place. If anyone has any questions or comments or suggestions, certainly feel free to email or call us anytime. And I hope you have a good rest of your day.
And at the end of your package, thank you for attending. We'll say that our contact information is at the end of the package, and we do